Hudson View Park versus Town of Fishkill. Counsel?
Good afternoon, Your Honors. Lee Lefkowitz from Zarin and Steinmetz. On behalf of the appellant, may it please the court, I'd like to reserve 3 minutes for rebuttal.
Yes.
If we are going to do anything about how difficult it is to build housing, statewide policy should promote agreements like the memorandum in this case, which was all about good government, an open process to review and entertain a rezoning application, and preserving legislative discretion.
Well, in your complaint, you accepted the axiom that zoning changes are in the absolute discretion of the legislature, right?
They definitely are, and the MOU preserved that discretion of the
How so?
legislature. At the end of the process, the town board could vote however it wished. It could have voted yes.
They couldn't say, no, we don't want to look at this right off the bat. That's one of their options.
So right off the bat, they chose to entertain the application. They chose to enter into the MOU, so they chose to entertain it. They chose to exercise their discretion to enter into the MOU and entertain this application. What the MOU committed Fishkill to do was to not terminate in the middle of the process before the applicant could get all of its studies and materials.
Then that curtails their discretion,
It
their
doesn't
ability
curtail-
to act.
It doesn't curtail their substantive legislative
But
discretion.
you agree it does curtail some choice.
Yes, it curtails their ability to not do nothing.
And without the MUO, they normally could do that.
There is,
They could end the process,
I'll
correct?
note that this court has never opined on that. There are some appellate division cases, frankly, which are one or two paragraphs, which do assert that a town board doesn't have to take up or continue review of a rezoning. This court has never rendered that decision, and I'll note that every other land use application.
But with respect to their own discretion, you're saying they're supposed to follow it because there was an agreement, but without the agreement, they could exercise their discretion, correct?
Under those appellate division cases, yes.
But
they-
you didn't preserve any argument challenging that line of reasoning.
Correct.
Right.
Our briefs.
You're
have
working
it-
on the assumption that you have locked them into something. And
We're
all you
working
want
on-
us to say is, yes, it was lawful for you to lock them into something.
Yes, we're working under those appellate division cases. In fact, those cases are what motivated the MOU in the first place.
How far does that proposition go in your view? Could, for example, there have been an MOU that would be enforceable, that would bind the actual determination, the outcome?
No, not
Why
under.
not? Why is that different? Why is the exercise of power here different from that hypothetical?
Under the cases we were working with at the time, the doctrines of contract zoning and term limits, which are the two doctrines that are at issue in this case, the cases like BT Holdings and Save Harrison, where courts have found those don't violate those doctrines.
But with respect to the term limits doctrine in particular, what I'm grappling with is how far do you think one legislature can go to bind the next? What kinds of, and please, set to the side proprietary functions, right? What kinds of decisions can be bound?
Under that doctrine, quite many decisions can be bound. So, in fact, many of the federal cases we've cited, like Windstar, these are cases where future legislatures are quote-unquote bound to pretty substantive policies. In that case, it was tax treatment of savings and loans banks at the time who were taking on bad loans. Courts have held, yes, you can be bound to really substantive issues like
So
that.
what's the limit? What's the limit, though, on your view about how far?
The limit is that you cannot prevent a future legislature from legislating. So, for example,
Yeah, but
if in this case we had said you must change zoning, even if you're a future legislature, we cannot force a future legislature to do something like that. That's where I draw the line.
Can you require that a future legislature approve, for example, a particular zoning variance?
No, you couldn't do that.
Could
Okay.
you have required that they, sorry, in front of you, could you require that they do it before the next elections? That they
That
conduct
wouldn't
a review?
violate term limits, but it could violate contract zoning, which is the other doctrine we're dealing with. So the doctrines that we're dealing
Mm-hmm.
with here say you cannot predetermine an outcome.
No,
You can-
I'm not asking about the outcome, just they finish the process, whatever it is.
Oh,
before.
so if it's about finishing the process?
Finish the process.
Yes, absolutely.
You could have
That's
contract-
exactly what
you-
we're, I'm sorry, Your Honor, I
Yeah.
thought you were
I
asking
just
about.
want to be clear. You think that they could contract to, you could have contracted to have them finish the process with whatever result before the legislature, the state, the town board, whatever is turned over.
I think that's a difficult question, so.
Well, that's why I asked
if the, if the MOU in that case said you must finish the process on a date certain
Yeah.
before that, I think that
On or before.
a potential issue you could have is could you actually get through the statutorily directed process in that time?
Suppose you could.
Suppose you could?
Suppose you could. Could.
As long as the process was completed and all statutes were complied with, then yes, I think you could do something like that.
Why would that even matter? If you got the other side to agree, if you made that agreement and you reduced it to a writing, really, who cares if it was a realistic expectation or not? You now have a contractual right, don't you?
We have a contractual right, I think.
No, I'm
that-
saying in this hypothetical,
Yes, but.
where you
and-
have to finish it by a certain date, probably before the next legislature comes in. If they agreed to that, I would think you'd come here and argue the fact that they're now arguing that that's not feasible is immaterial because you have a contract.
I agree with that, and also I think this goes to Justice Halligan's question. What we're asking for in this case is monetary damages. We're not trying to force a vote, so we're not even seeking to require a future legislature to do anything. In this case, all of our causes of action only seek damages that we incurred in reasonable reliance on our contract, which says we were going to get through the process.
Counsel, I'd like to ask you something a little bit different. You opened your remarks, I think, saying that how we decide this case will, in your view, have an effect on an ability to build and to increase housing stock. You appealed, as I recall, as of right, claiming this was a constitutional rule. Do you still hold that position?
Absolutely, yes.
So if we decide against you, and this is a constitutional rule, the legislature couldn't fix this then, right?
It
Without a
depends.
constitutional amendment, right?
Well, I don't think that's true. So,
The legislature could fix a constitutional decision from this court?
if you agree that, if you said it's not constitutional,
No, but if we agree with you and say, yes, it's a constitutional rule, and you lose, that's a
your
constitutional rule.
interpretation of the Constitution, yes, would bind the legislature and
So
would.
there's no legislative fix if you are right in getting here that this is a constitutional rule.
Yes, that's correct. Yeah.
Does your assertion that it's constitutional turn at all on the fact that it's a local government, or would you say the same thing would be true for the state legislature?
The same thing would be true for the state legislature. And in fact, the cases that we've cited in particular note that all of this derives from constitutional premises of state sovereignty.
So it doesn't turn at all on, powers conferred or not conferred by the municipal home rule law provisions in the Constitution or statute?
No, it ultimately traces to doctrines of state sovereignty, going back to the founding, going back to the Federalist Papers, to the Fletcher case, the Windstar case. There are cases where courts have found that same federally constitutional
So is it
issue.
a common law that you're relying upon, that it's constitutional? Or is it a
No.
provision within the Constitution itself?
Well, what I'll say is there's certainly no provision of the Constitution that we're pointing to. These are implied constitutional doctrines that courts have recognized as being part and parcel of the Constitution dating back to the late 18th century. They derive from common law of Great Britain and how state sovereignty was being interpreted when at the founding.
And are any of those constitutional issues that you're talking about now, were they raised below by you?
We didn't raise them. They are the only ways in which either court decided this case. They were raised as defenses by my adversary in both Supreme Court and at the appellate division. These two doctrines, contract zoning and term limits, which trace to the same federal constitutional premises of state sovereignty called the unmistakability doctrine, the reserve powers doctrine. These doctrines are what Fishkill raised in defense of our case. They are the only things we've ever argued again about what the two of us in Supreme Court and in the appellate division. They're the only two reasons that the appellate division found against us, so they are directly involved here. And we've got half a dozen cases dating back to the 1800s that recognize that these doctrines dealing with when can a legislature contract away its legislative authority and when it can't. These doctrines, term limits and contract zoning, are modern names for those same federal principles. I want to turn to the question that I opened with, which was, this is all about how difficult it is to build here in New York and the demanding land use process that we deal with here in New York, and contracts like this, which make the baseline commitment by a municipality to at least review an application. Every other land use application, a variance, a use variance, which is not so different from a rezoning, a site plan application, an environmental review, all of these are entitled to a vote. If you put in an application, you get an answer from your government.
Entitled by virtue of what?
Town law, so town law
Okay, so by
267A,
virtue
for
of
example, requires a vote on a rezoning. So a
thought
variance. So each of these other applications.
But if they're entitled to a vote by statute, why do you need an MOU to secure that right?
Because this was a rezoning. Rezoning is the only one of all these types of applications that doesn't have something like that.
So it's only relevant, an MOU like this would only be relevant to a rezoning, not to a range of other land use determinations where it sounds like you're telling me that there is a right to an answer pursuant to statute, and presumably one could go to court to enforce that right.
Correct.
Okay.
You see those cases all the time. Those are mandamus cases where you bring case to Supreme Court requiring a municipality to give you an answer on your application.
And as it relates to building, are you saying that these cases that we see all the time are only related to zoning questions?
With respect to mandamus or requiring a municipality to act?
Whatever the dispute may be.
In my world of land use applications, yes. These are applications where, for example, if you apply for a variance, the municipality won't act, you could bring a mandamus claim requiring them to vote. Rezonings are the only type of petition.
Doesn't have an inevitable adjudication or hearing attached to it.
Exactly
So
right.
presumably, you could, notwithstanding the two, arguments made by your adversary, you could enter into an MOU that would not run past the term of a legislature without running afoul of those doctrines, yes? Wouldn't implicate it because there wouldn't be the same
You could.
question. And so how long does this process generally take? How often would there be a concern that you would have an agreement and then a new legislature would come in?
Every time.
Well, every time?
Yes, because the land use process, particularly rezonings, take years. And they don't even have to take years for this to come up every time. One town board member could resign or could change over in November. These are 2-year terms. So the answer is yes. Every single one of these applications takes many years, especially big projects and especially rezonings, which are the most involved of these. If there are going to continue to be public-private partnerships to make big things happen in New York, urban renewal, economic revitalization, brownfields cleanups, if any of this is still going to happen, it's going to require municipalities to be able to contract with private parties to make things happen in this state. All of them take more
And
than.
are you suggesting that for the projects that have gone forward, that the only reason they were able to is because they've had these MOUs?
If you were to look at the last 6 or so biggest public-private partnerships in New York, at the center of every one of them, there's going to be a contract just like this that sets forth at least the baseline obligations of each side, procedural
But
obligations.
won't a lot of that be covered by proprietary function? I mean, this perhaps is distinct, I see your lights on, but distinct because there's an argument that it is more of a governance function.
The doctrine that we're now talking about, term limits, it shouldn't be looked at that way. There's 2 or 3 cases total on term limits. One of them, yes, mentioned this proprietary versus governmental
just
distinction,
asking-
but Monroe Monroe talked about how that doesn't even work. It's a difficult question in the land use context. It should be subject to a balancing test. When it's just a vote, just a procedural vote, it should fall on the side of the balancing test that it should be allowed to go into the next legislative term.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Brian Nugent on behalf of the town of Fishkill, respondents, the law firm of Ferrick, Nugent, McCartney. Your Honors, I think to start with, out of these two doctrines we're discussing today, the term limits doctrine is undoubtedly violated here under this Court's determination in Carides, which specifically stated that elected officials must be free to exercise their discretion in these governmental matters, and that they cannot bind future boards in that discretion. And in this case, it's
What do
clear.
you say about the argument that the ultimate decision, that they're free to vote with whatever way they will?
So, Your Honor, I think that if we take away the discretion, in which the appellants acknowledge is absolute discretion when it comes to zoning amendments, and now we sign an MOU and the next board cannot terminate that review, we're clearly taking away from what we're describing and all conceding is absolute discretion.
So
How do
any
you-
part of the process that's impacted violates the term limits?
I think anything that's a governmental power, such as zoning, where there's an absolute power to consider, not consider, and I'll say it's rare in the governmental context that we have. As my colleague mentioned, there's applications for site plan and variances that have a process, and a municipality cannot just say, we're not listening to you.
And how do you justify or explain that distinction, that in almost every other land use process, there is a set, an inevitability of a consideration and a vote, except for zoning? Why should it be that way?
So I think the very reason for that is that, typically municipalities adopt zoning and a comprehensive plan. And when you're coming to a municipality, you're asking to say, I want you to change this from what you've already determined is the appropriate uses and zoning and setbacks in that particular district. And it's a request, and I think that's why there is absolute discretion, because
Isn't everything a request? A request for a permit or a variance? Or
yeah, but the
whatever?
difference is if you have land and you have a zoning code that says you can develop it, you've been given that right to file that application and obtain a determination from the government, which is not the case if you're saying, I want you to change that zoning law and make it more suitable to me. Secondly, I think if we ended up with a process by which all developers were able to lock municipalities into having to review zoning amendments, then we'd be dealing with so many of those requests, and we would have
Are
to.
these
ask you-
MOUs unusual, or is it part of common practice?
This MOU, in my view, is unusual. There are many MOUs in development, but more times when you see those MOUs, they're setting forth an understanding of, which is why they're usually called memorandums of understanding, because zoning codes don't necessarily address every particular step in the process or how we're going to handle it. So there would be an MOU to say, okay, you have a site plan, a special permit, a zoning variance. How are we going to move forward on those? And so everybody's on the same page, essentially. But they don't bind the government as this one does with that paragraph that basically tells us, number one, you can't terminate your review of the zoning amendment. But on top of that, it imposes these conditions that it must be based upon empirical data. When it comes time to make that final determination, you must base it on empirical data and other factual bases. I'm sorry, Totali?
Not at all. On the question of whether there's a constitutional issue before us, if the term limits doctrine isn't constitutional, you argue, I think, that instead it's an issue of an absence of delegated power. I'm not sure I follow that, and I guess I think if it's not constitutional, I'm not sure what it is. Can you address that?
Yeah, so I think that when we refer to the absence of the statutory authority, that, of course, is the exception. And I would suggest that if the term limits rule was really something that was entrenched in the Constitution, then we wouldn't have statutes that actually authorize term limits violations, so to speak, in some cases, such as urban development. We have statutes that specifically say a municipality can enter a long-term development.
Yeah, but a lot of that is a proprietary function, right? I mean, I am not sure where the source of that kind of constraint would come if it wasn't constitutional in nature and wasn't really a constitutive part of what it means to have a legislature where you elect a new group every X years.
Yeah, I think the court's decisions have described it as public policy. Now, I'm not saying that we can't, and I think this is what the appellant argues and does. The question for this court when it comes to jurisdiction is not, can we trace this somehow? Can we go back to constitutional decisions and find some discussion about not binding future boards? The jurisdiction of this court is for substantial constitutional questions that are directly involved. And that's what we're arguing is not present here. And I think the appellants had difficulty presenting that constitutional argument because they don't identify any provision of the Constitution that is invoked.
To follow on your point there, if the question of whether this is a substantial constitutional question is itself substantial, does that give us jurisdiction?
If it's not substantial?
No. You're arguing back and forth, I think, about whether this is or is not rooted in the Constitution. Could that itself be a substantial constitutional question?
That's a good question, Your Honor. I guess if, it's not obviously an interpretation, but a question of is there term limits found in the Constitution? But I would tend to believe, and we're maybe not collectively as bright as this panel, but somebody would have found that. We would have found the source in all of this briefing, or it would have been argued in the lower court if it was a substantial constitutional question. There would have been some mention of the Constitution somewhere in this case, and there's not, because it's generally viewed as a public policy.
I guess what I'm asking is, does our jurisdiction depend on whether you are right about the constitutional question or simply about whether the constitutional question is a substantial one for our decision?
I think it's whether the court determines there's a substantial constitutional question. And whether that means if it's in there or not, I don't honestly know, if the question is, do we have one? But I think that it's at least well established in New York State, the term limits rule, and it's reflected in your decisions. And it doesn't speak of only outcome. It speaks of binding legislative discretion. And I think, in fairness, the appellants, if you read the briefs and the complaint, have also backed off that position about the offending language in this MOU. Because on appeal, they tell you, we're not trying to enforce, as part of our breach of contract action, this empirical data language. But then when you look at paragraph 112 of their complaint and the record at page 60, it very specifically says the town breached the MOU, and point number 2 in that paragraph is the exact language that they're now telling you they're not trying to enforce. And I think, I'm not pointing that out for the inconsistency, but for the fact that the appellants themselves realize that the language of this MOU is problematic in the sense that it binds the 2020 Town of Fishkill Town Board when they came into office. And I don't think there's any question in this case that there is a term limits rule violation. As to contract zoning, then, as my colleague pointed out, there's no term limits violation if we don't get to the next board as we did in this case. But when it comes to contract zoning, that becomes void or legal at the point when the contract is entered into by the 2017.
What is your response to the public policy argument that the other side is making about how difficult it will be to do development projects if you can't, hold a legislature to a deal?
Your Honor, first I would point out that I know it's not a factual part of the record, but this difficulty in building in New York State, I've lived in New York State all my life. I certainly see no difficulty with
Okay, but
building.
why wouldn't it inject significant uncertainty into the development process?
In respect, are we talking housing or just the uncertainty that we won't be able to build without these agreements?
Well, I think your adversary is arguing that if one legislature cannot enter into an MOU which runs past the end of the term of that legislature, that it will make it more difficult to do large-scale projects. And I assume that's because the uncertainty that will engender as to whether the next legislature will stick with the deal will be problematic. So I'm wondering what your response is to that.
Yeah, absolutely fair question. So in this case, I think it's important to note that the town board in 2020 did not terminate this project, did not terminate.
I know, but it's a broader, we're trying to
Right, but it highlights the point that the problem is that in this case, they rolled the zoning amendment into the process. MOUs occur all the time. Developments happen all the time. They don't always require zoning amendments, number one. So they're building as of right, and as I touched on before, they're sometimes just reflecting the process, mostly so that both sides are on the same page as to how they're going to move forward. But that's something different, right? When you roll the zoning amendment and it becomes, and it's critical to your development, some developers pursue their zoning amendments up front for this very reason, because they're concerned with that discretion and it being denied. So they pursue the zoning amendment. Once they have it, now they're just proceeding as of right. So anything in an MOU is just reflecting what the statutes, the
So
local
get the
laws.
zoning change first and then start developing your project is
That's how some
what you're
developers
saying?
proceed, because they have the very concern that arose here, that a new board could come in and say, we don't like the zoning change, and reject it. So they go for the zoning amendment, and then they're proceeding as of right. There might still be an MOU, but it's not binding anyone. It's basically setting forth a process and saying, this is the steps and the order in which we're going to do things.
I take it you don't think that a state statute that required municipalities to see a zoning application through to a decision would violate the term limits rule or the contract zoning rule?
If a statute required that?
A state statute.
Well, I think that that would be a legislative matter, and if the legislature eventually said, you are going to
If you get an
process.
application, you got to process it through to conclusion.
Yeah, I think if it was a statute, other than obviously a challenge to the statute, which I would bring, it would be,
Well, on what
you
ground?
have to follow the statute.
On what ground?
Well, I think that, again.
That's what I'm asking. Would you bring it on
Because of the
true?
nature of a statute like that tells the next board in the case, but you're right, it would specifically authorize it, which is exactly what I have to say. Caridi said, if we had a statute and it specifically said, you can do this, we probably would not be here on this case, at least. So if there's any other questions, otherwise I rest on our briefs.
Thank you.
Thank you, Your Honors.
Council indicated that rezonings are different because it's a developer coming and saying, I want you to change this. That's not true, and it's not even what happened here. Fishkill needed more housing. It was in their comprehensive plan that they wanted more housing. The then Fishkill supervisor came to my client and approached us about
Yeah, but you know
doing-
what, like you mentioned public policy, and those people ran on stopping this development, and the people voted for them. So it doesn't matter if they came to you or, you know, the circumstances that brought you there. The fact of the matter is the public said, we don't want this. In fact, they came out and said, good news, this development is now stopping. That's sort of democracy, no?
Their recourse under the MOU was to vote no on it then, not to disallow us from getting all the studies and data in front of them and making our case in the public. That was what we contracted for, was the ability to compile all the studies, submit all the environmental analyses.
So if they could just reject that outright, you agree to that, right? That
They
if
could
they
vote
actually
no,
looked
yes.
at it, they could decide, we don't want to proceed. Correct?
That-
Okay.
They could vote no. They
Vote
couldn't.
no?
Yeah.
Okay, all right. So what's the benefit you get?
We get to
If you know that they can always vote no.
we get to make our case in the public. This process requires us to compile all the studies and data. We're incurring all the costs. If Fishkill wanted to rezone on its own, it would have to pay all the planners and all the engineers and all the consultants, but they came to us and said, why don't you bring a rezoning petition? Now we're paying our own planners and engineers as well as Fishkill's
Is
costs.
that answer exactly accurate? I mean, they could vote no, but they have to vote no according to a set of standards that were laid out in the MOU, don't they?
No, not a set of standards. They had full legislative discretion to vote no for whatever reason.
So you're no longer pressing the empirical data point that's in the complaint?
We're not asserting that that was violated.
Why-
It-
Well,
Could
not
you,
that,
though?
now that's avoiding the question. It is in the MOU.
Yeah.
So if they went ahead and just didn't look at anything, and just voted no, would you not be arguing, wait a minute, you were supposed to take into consideration the following in the best interest of the town?
The
And you
point-
didn't do that.
We're not arguing that. If we.
Well, I know you're not
if-
arguing it, I'm asking you about it.
If we tried to argue
Yeah.
that, this court could certainly find that that's contract zoning, but what we're arguing is that they didn't even let us get to the point of
But
getting.
the point is, it is in the MOU. I mean, the point is, it's already in the contract.
If this
right?
court has a problem with it, then it should sever that provision. We're not trying to enforce that provision. What we're saying is that if a town comes to us and says, you incur all the costs, all the years, all the expenses of studying this rezoning that we want, and all we're getting is the opportunity to persuade even this new board that was elected to say, we're going to stop this project. We have a right to get all the studies in front of them and try to persuade them and all the public.
Didn't you bundle this as a convenience to you all? I may have misunderstood your briefing. I thought that you were making some point in the briefing that you could have proceeded a different way, but you wanted to get all of this before the board.
I think
and that's in part why you wanted the MOU.
The point I think you're raising is we could have proceeded, for example, by a use variance, but that's much less desirable for a lot of reasons in the land use world. A rezoning is more comprehensive. It allows.
Yes, but that would have assured you that they would
under a
address it, no?
under a very different standard. So under that standard, you need to show dollars and cents proof
So
as to that
you're
you
doing,
can't.
all I'm saying is you're doing more than merely saying, well, I just want to vote. You're actually changing the standard by which they vote.
We couldn't have gotten a use variance. We could have used this property and put in a 300,000 square foot big box store that would have created way more traffic as of right. What we're suggesting is if we're going to go by way of a rezoning, the only assurance we wanted from Fishkill that we wouldn't get to the 11th hour having spent millions of dollars paying their costs and ours to study this rezoning, only to be told you're not even going to be able to present that to the public, the town board, but also the general public who comes out to these meetings.
So if we disagree with you, you still have other paths. You would have had other paths. You just didn't want to take them. That's my point.
No. We could not have gotten a use variance or any other kind of variance that would have allowed this project. If this is the project that Fishkill told us they wanted, this is the only pathway that it could have been done is through a rezoning. And if they were to do it, it would have been very costly to them. They were able to get a developer to bear all those costs and all those years. And the only assurance was we wanted to protect against the fact that suppose there's a change in politics in the town, that we get to make our case in the public. We get to submit all the studies. That's what that language empirical data was all about, is we just want to get the data in front of the board so that they have it in front of them and have been able to make our case.
Thank you.
Thank you.